Thank you, ladies and gentlemen. This is a much anticipated session. Sir Geoffrey Palmer really needs no introduction to this conference. As a result of a stellar career, barrister and solicitor, and currently now again barrister sole and senior counsel, law professor. His time in politics, of course, when he held the offices at various times of Minister of Justice, Attorney General, Deputy Prime Minister, and for a time, Prime Minister. Following Sir Geoffrey's parliamentary career, he established the public law firm of Chen and Palmer, and then he was later appointed President of the Law Commission. Sir Geoffrey is, of course, a Knight of the Realm, and he has a very high international recognition through his continuing involvement as a law professor on both sides of the Pacific, and as a result of his various appointments for the United Nations. There's really not enough time to recite the honours that Sir Geoffrey has accumulated. Suffice to say that he is an iconic New Zealander, and we are privileged to have him here to give his perspective on international dispute settlements as an experienced participant. Sir Geoffrey.
Kia ora and greetings to you all, and John, thank you very much for those kind but undeserved words. John, I first struck when he introduced me to the intricacies of West Coast leases. I'm not sure that I ever fully understood them. What I want to talk about today are some international disputes with which I had a personal involvement. And if you're interested in any more detail about it, you can read it in the Victoria University of Wellington Law Review. It's just come out, the June 2012 edition, and the piece is called Perspectives on International Dispute Settlement from a Participant. And what I want to say about that is that the thing that I found most useful in dealing with disputes of all sorts was an experience I had as a very young law professor in the United States in the late 60s, in which I was obliged to teach a course called Conflict Resolution. It was all the 60s, you remember, were quite interesting in many ways, and everyone thought there were new ways coming. In some respects, we're still waiting for them. But the idea of conflict resolution was, how did you resolve conflicts without going to court? That's a particularly un-American idea if you think about it, or it was then. And so we had to sit down and try and figure out how you did negotiations. And you'd do trial negotiations, and you'd then try and bring someone else in to see if a mediation could work, and you would look at the whole idea of this, and it was in its infancy then, and it was absolutely fascinating, and the students hated it because there were no rules. And the second semester, just to make it worse, international law was a compulsory first-year subject, and the idea was, how did you get to a settlement of a dispute internationally where you couldn't compel people in front of a court, which is the usual situation internationally. The students hated that as well. But let me just say that that whole idea, that radical curriculum change at the University of Iowa in the late 1960s, turned out to be very prescient in terms of the way things are now, because I think conflict resolution, alternative dispute settlement methods, and indeed the way in which we approach international law questions have all developed quite a lot since then. Now, the particular disputes that I want to talk about, I'll go through. The first one is the nuclear test cases against France that went to the International Court of Justice not once, but twice. And you will, those of you who are grey-haired, and some of you are, will remember that New Zealand got involved in a series of disputes with a number of nations over its anti-nuclear policy, and the anti-nuclear policy really was driven by French nuclear testing in Muraro. And Australia and New Zealand took France to the International Court of Justice in 1974. So that's the first dispute I'm going to talk about. Then there was the dispute between the United States and New Zealand over New Zealand's anti-nuclear policy. That had a number of elements in it, and the legal elements have never really ever been resolved deliberately by both sides. Then there is the dispute that New Zealand had with France over the Rainbow Warrior, when the Rainbow Warrior, a ship owned by Greenpeace, was sunk in Auckland Harbour on the 10th of July 1985. That was a really heavy, difficult dispute. And strangely enough, of all the disputes that I'm dealing with, it is the one that was the most completely solved. The next one is the United Nations inquiry into the Gaza flotilla. You will recall that 6 ships sailed to Gaza against a blockade that Israel had imposed on Gaza, and there were 600 people on the Mavi Mariner vessel, and 9 of them died when Israelis with force boarded the ship. I chaired a UN inquiry into that, which was a pretty interesting but not an easy experience. And the last one is the efforts to reach rapprochement at the International Whaling Commission. If you do want a job of little profit, ease or honour, I recommend you become New Zealand's commissioner to the International Whaling Commission. Very, very difficult and the worst insoluble dispute that I've ever struck. So what does all that mean? The first insight I have is pretty barren and not very useful. There are, as far as I can see, no general rules or general theories about what will work in settling international disputes. They have many different features from domestic disputes, but they have many similar features as well. And what I have learned really is quite simple. You can only settle disputes if nations want to settle them. There have to be incentives to settle, and often there are not. And if there are not, it's not going to work. Now, there are a lot of people who write theories about all this in international politics, and theorists have their place and are useful. But I have never found a theory of international dispute settlement that actually works well. Roger Fisher years ago wrote a great book called International Disputes for Beginners. That's very good. And there's another good book called Getting to Yes, which is a very useful book. And I have found those 2 books more useful than any others in doing the stuff that I'm talking about here today. But at the international level, you do have Article 33 of the United Nations Charter about the Pacific settlements of disputes. Now, of course, in these days of Syria, one would have thought that we don't have Pacific settlements of disputes, but actually we do, or we're supposed to have, and they're set out in the Charter. And it's very similar to what goes on domestically. We have negotiation. Now, a lot of people negotiate a lot of the time, and there's a lot of positional bargaining goes on that is pretty counterproductive, and a lot of people really don't get how to diffuse all that and how to kind of get to a place where you can even start to talk about settling the dispute. And diplomats are professional negotiators. That is what they do. And a lot of discussion goes on about all these sorts of disputes that I'm going to talk about, but, you know, the whole question of inquiry, which really comes down to fact-finding. Sometimes the disputes are characterised so vastly differently on each side that one wonders if you're talking about the same dispute. And actually you're not, because in their heads it's different. And it's in their heads, when you're dealing with a nation state, that it's so difficult to get to. Then you get the mediation, and there are examples of international mediation that have been quite successful. Indeed, the Rainbow Warrior, the Prime Minister of the Netherlands, Ruud Lubbers, began to mediate in that. It was helpful, it was. Then we've got conciliation, which in international levels is quite a formal process, and which has conciliation commissions written into a number of international treaties. But when you get up the hierarchy to arbitration and judicial settlement, you're talking about hard law traditionally administered. You get a bit more flexibility with arbitration because you can appoint the arbitrators. Usually each nation appoints one, and the two arbitrators choose the third, and the third is the chair. That can work quite well. And then you get to judicial settlement at the International Court of Justice. And the International Court of Justice, of course, is not a court that you can access easily unless both nations agree that its jurisdiction applies. That leads me to the second insight. The disputes that I've seen really involve characterisation. How one characterises the dispute turns out to be a vital matter very often in getting it to resolution. And you really have to do the thinking at the beginning, not the end. What is this dispute about? And New Zealand had a few years ago the southern bluefin tuna case against Japan. And the critical issue there was it a case about the United Nations Convention on the Law of the Sea, or was it about an interpretation of the Southern Bluefin Tuna Convention? Now, that's quite a tricky issue actually, but the answer to that issue depends on whether you can litigate it or whether you can't. We did, and ultimately we didn't win. So, one of the problems is that compulsory adjudication is really not at all popular in the international sphere, and it's often not available. But there are exceptions to that. The World Trade Organization has a compulsory dispute settlement mechanism. Look at Australia and apples. Since 1922 they've kept us out. Why did they have to give up? Because an international appellate tribunal at the WTO said, you lose. And that is compulsory adjudication, and even the Americans have signed up for that, and they don't sign up for much. So we've got a situation, of course, where only of the P5 on the Security Council, only the United Kingdom accepts the compulsory jurisdiction of the International Court of Justice. All the others have given it away. Some of them never took it up in the first place. But I do not want you to run away with the idea that international law doesn't matter. I was once taught by Professor Hans Morgenthau at the University of Chicago, and he taught international politics, and I used to walk across the midway from the law school to hear Professor Morgenthau, and what he was preaching was absolutely antithetical to what they were teaching in the law school. In the law school they said, this is about law, there is law. Morgenthau said, international adjudication is unable to impose effective restraints upon the struggle for power on the international scene. Now, regrettably, sadly, that's still pretty much the case. New Zealand and Australia tried hard when the UN was set up to make the jurisdiction of the International Court of Justice compulsory, and it failed. We also didn't want the veto of the Security Council. We failed in that. Imagine what the world would have been like had we succeeded. But it is important to say that international law does exist, it is followed, and it does matter. in the settlement of international disputes. Well, with those precatory words, let me get on to the nuclear test cases. Now, the nuclear test cases, of course, were very controversial, and France used to accept the compulsory jurisdiction of the International Court of Justice, and when we filed this case along with Australia, they immediately renounced it, and they still renounce it. And this made life pretty difficult for the International Court because they didn't even turn up to the argument at The Hague. And of course, when therefore the President of France announced that they were going to cease atmospheric nuclear testing, which they had started on Mururoa when Algeria was no longer available to them, then the court said on its own motion, without ever asking anyone, this litigation no longer has any object. It's moot. You wanted them to stop testing, they've stopped testing, goodbye, go away. Now, the interesting thing about that was that obviously the whole embarrassment of doing a compulsory adjudication about whether nuclides that were coming onto New Zealand and disturbing the amount of radiation and so on, that was a real issue. And 4 of the dissenters said, hell, this is really a dispute. This has not been mooted. This is real law. Let us have the answer. We still haven't got it. In 1995, the New Zealand government resumed that case at the International Court of Justice because there was a paragraph in the judgment that said if something happens, you can come back. And New Zealand came back, and in that time I was made the ad hoc judge at the International Court of Justice, and that experience rather disillusioned me with the state of international law and the way it was administered at that time in the court. I'm assured by Ken things are better now, but they certainly needed to be because the court did not want to hear this case. I had to bang the table and say, look, these New Zealanders, they think when you go to court you should be heard. The French judge said, well, we don't hear them in France. And I said, well, look, guys, if you don't hear them, there'll be a lot of trouble. Anyway, the thing that I draw from that experience is that the higher the level of political concern on an issue, when you're dealing with an international issue, the harder it is to have satisfactory international adjudication. In nuclear matters, it's very difficult. A couple of years after the resumption of this case in which New Zealand lost, I think, 17-3 or something, I was one of the dissenters. Christopher Weir-Mantry wrote a wonderful judgment there about the international environmental law, and that was really the point of the case. But it never got to be really stated that way because it was too embarrassing and too difficult, and people wanted it to go away. And you know, you can make adjudication go away by just not dealing with it, and often that turns out to be what nations want. The insight that I make from that, therefore, is quite simple. The higher the level of political concern, the harder it is to have satisfactory international adjudication. You'll get it on boundary disputes and things of that sort, and you often get it in fishing matters, but when it's really highly political, ministers want to keep control of it themselves. They don't want to have someone else telling them they did wrong because they can't control that. It's politically unmanageable. They don't like it, and it might hurt them. And that's especially true if they're dealing with an inflamed public opinion. The dispute over ships visits in ANZUS really arose from what is a very loose set of legal obligations in the ANZUS Treaty, which says each party recognises that an armed attack in the Pacific area on any of the parties would be dangerous to its own peace and safety, and declares it would act to meet the common danger in accordance with its constitutional processes. Now, New Zealand, as is its wont, wished to have ANZUS and its anti-nuclear policy. The United States wished to have ANZUS, but not New Zealand's anti-nuclear policy. And in the end, the United States was able to get its way because they would not permit New Zealand to stay in ANZUS and maintain its anti-nuclear policy. There were, in that case, pretty extensive negotiations. There was an exchange of legal views, because what New Zealand said about the language I put up earlier was, well, it doesn't say anything about ship visits there, and we can decide who comes. But that wasn't going to get you anywhere. There was an vigorous exchange of legal views, but the legal issues were never resolved, and the dispute wasn't actually resolved either. What happened was that, in the words of George Schultz, we part as friends, but we part, and that remains the position. Now, the Rainbow Warrior was a horse of a different colour altogether. It was a very, very difficult dispute. All the issues were eventually solved. There were a lot of legal issues. There were a lot of political issues. There were secret negotiations that were the key to actually solving it. There was a ruling from the Secretary-General of the United Nations, so you see there's a sort of third party getting in there, very useful, but it wasn't all that it seemed. There was a further arbitration over the removal of prisoners from Hao Atoll, and indeed one would say that in the end politics was central to this, not the law. Reparation and apology, to which New Zealand was entitled under international law, could be secured actually only by releasing the prisoners to France. While New Zealand had legal power to do this, it wasn't obliged to do so, and the political heat from doing so here would have been very considerable and substantial. What looked good to France, the release of the prisoners, was not a matter which they had a legal right to, and New Zealand wouldn't agree to it. And as the negotiations bogged down, I gave a speech at the UN that year and talked about this, and the French Foreign Minister was there, and I started negotiations with him. Although he had a PhD from the London School of Economics, he insisted that the negotiations be conducted in French. There wasn't a hell of a lot of sort of cooperation there, and I don't know whether you know this, but you know, we caught these people. The New Zealand police caught them and apprehended them, much to their surprise. And the French government would never actually admit that they'd done this. So what happened was the Foreign Affairs sent the file to France and said, "Give them that, the police file." And after that, they admitted that they'd done it. We had a lot of evidence. But in international things, people hardly ever admit what it is very distasteful to admit, even though it might be right. So the whole question, really, the issues there were, we wanted an apology and compensation for France for violation of our sovereignty. We wanted compensation for Greenpeace and the family of the dead crewmen, but the difficulty with that was, of course, that we couldn't assert the claim of a Dutch national. And then we had trade relationship issues because they started intercepting our exports of brains, sheep's brains, to France, and that caused another aspect of the dispute. And then there was the fate of the 2 French agents imprisoned in New Zealand. So, in order to settle this, Chris Beebe headed up a negotiating team in Switzerland, and a terrific amount of negotiation was finished and completed. But you had to have kind of the cloak of legitimacy over it, because both nations had fought like cats over this, both had heavy domestic constituencies who hated all of this, And what happened was that they said, well, go to the UN and get the Secretary-General to bless this, and the Secretary-General therefore made a ruling. And what was put in front of the Secretary-General was the whole of the negotiated settlement, plus the Secretary-General actually decided the amount of reparation, which was, I think, $7 billion US. And that was okay, except for the fact that then the French government decided to remove the prisoners from Hao Atoll, where they had been placed as a result of that settlement, and we invoked the arbitration clause, which was fortunately in agreement because we could see that the political situation in France was likely to be very difficult. And we prevailed again in that arbitration. So that and now that dispute is entirely behind us. I think our relations with France are probably very good now and not hindered by this matter, which was for many years a really serious aggravation in our relationship. Well, now, I want to deal next with the Gaza flotilla. Now, the facts of that were pretty grisly, and the methodology of the inquiry, I mean, the inquiry was very interesting because I was the chair, the vice chair was President Uribe of Colombia, and then we had an Israeli who was the former head of their Foreign Affairs Ministry, and a Turk who was the former head of their ministry, and those two knew each other very well because they'd done a lot of negotiations together over the years, and they both wanted this to be settled, but that wasn't to be. And in the end, President Uribe and I had to write the report, and they didn't agree with it. Especially Turkey didn't, but Israel couldn't agree with the bits that were unfavourable to them either. Now, the methodology that went here was to get reports from the parties, and the Israeli government set up a whole commission of inquiry that went on for months, and they held witnesses, and we got their report. Turkey did it a different way by interviewing witnesses themselves, and then what we did was to read this and ask written questions, and then we could bring the point of contact, the officials of each government before us, and ask them questions and let them argue with us, and that we did. But you see, a UN inquiry does not have the capacity that a Royal Commission in New Zealand has to compel evidence. And that puts you in a position of some weakness. On the other hand, the nations whose conduct is being inquired into are subject to the fact that everyone is watching them, and you might say things about them they don't like, and they better not mislead you. So there's a sort of balance of terror in an inquiry of that sort. And there's a lot of pressure from the international community to try and reach some sort of settlement. But what we did was to write as an objective a view as we could about what happened. We didn't really, the report, if I can characterise it, sort of says a plague on both your houses, really. And so the reason that it was never settled as it should have been with reparation and an apology was that the Minister of Foreign Affairs in Israel came from a narrow part of the Israeli body politic and wouldn't agree to any settlement, and they didn't want to upset the apple cart, so they wouldn't agree. They nearly did, and some ministers did, but they didn't in the end. Well, the insight from all of that is that whatever techniques of dispute settlement that you use, the critical ingredient in settling a dispute is the political will of ministers to arrive at an accommodation. Because in international disputes, if there's a lot of internal politics behind it, sometimes the room to manoeuvre is greatly reduced. And it was in the case that I just mentioned. Well, we come to the International Whaling Commission, which is a multilateral convention with 89 members, made in 1946 in Washington by 14 nations, of which New Zealand was one, who were all then happy whaling nations. The world changed, the treaty did not. In 1986, a moratorium was established so that there would be no more commercial whaling, because the International Whaling Commission had failed in its task of conserving whales, and many of them were dying out. The blue whale, the largest mammal ever to inhabit the planet, was critically endangered. Now, the moratorium on commercial whaling was not accepted by Japan, and it wasn't accepted by Norway or Iceland. And in essence, what happened was that the Japanese looked carefully through the convention, and having been forced, the Norwegians made, as they were legally entitled to do, a reservation to this moratorium, and they were never bound by it. Japan, for reasons I won't go into, did accept it and then wished it hadn't, and looked at Article 8, and Article 8 of the Convention said you could go scientific whaling. And if you went scientific whaling, you could take as many whales as you liked, they said, because the Convention didn't stop it. And you had to consume them as well, because you couldn't waste them. And so the result, well, that's what the treaty said. Now, the result of this is that we have a terrific insoluble dispute, and I was chair of a group that tried to produce a diplomatic rapprochement to this. 2 years of travelling around the world endlessly at meetings. We had one in Chile that lasted 2 weeks. We had it in Honolulu. That's not a bad place for meetings, but the result of all this was that we tried to produce a compromise in which the number of whales killed, even under the scientific whaling exception, would be controlled internationally. So we draw up the numbers of whales that could be killed, which is quite many more whales killed than should be, is about 2,000. And there could be no more. And we particularly wanted to limit them in the Southern Ocean because of the trouble that happens there every year. But we never got the numbers in the Southern Ocean down quite low enough to make it feasible, although we got them down. So the result is that all the NGOs, a lot of them, opposed this because they said the purity of the moratorium should be maintained. The difficulty is the leakage in the moratorium from scientific whaling was sort of so prodigious that one couldn't see what the use of the convention was. But in any event, that diplomatic effort failed, and Australia is taking Japan to the International Court of Justice about that, and that case has been filed, and I expect New Zealand will intervene in it to help Australia, because we are a great friend of whales and we try and conserve them, having been a whaling country for a long time. So there is, in all of that argument about whether you could kill whales sustainably. I mean, there might be as many as 500,000 minke whales in the Southern Ocean. Are you really saying that Japan can never kill any of them? Well, that's the case for preservation. You don't need to kill whales. They were used for oil. They're only used now for eating, and people don't need to do that, so you shouldn't kill any. Well, that is a very hot international dispute, and I see no end in sight for it. So the conclusion that I draw from all of this is very modest indeed. Political incentives in international disputes are the key drivers. The shadow of the law does hang over every dispute and can have an important part in resolving it. There is more scope, I think, for compulsory adjudication than we have. I think a lot more disputes would be settled if the prospect of compulsory adjudication was real and it was available. I think third-party involvement in international disputes can be very useful, but apart from that, I'm bereft of ideas, and I hope the next generation does a lot better. because the world's a hell of a mess. Thank you.
We have a few moments available for questions, so I'm sure Sir Geoffrey would be pleased to answer any questions from the floor. Could you just wait for the microphone, please? It's being recorded.
Free trade agreements, is there scope for compulsory adjudication and or mediation in that context?
I think the free trade agreements, New Zealand is a signatory of a great many of them. I think the dispute settlement mechanisms under them is not something I've studied closely, but I dare say, I do know, for example, in the NAFTA one, Canada and the United States and so on, there's plenty of adjudication possibilities in that angle. I think that there really probably should be some, I just am not sufficiently knowledgeable about those treaties to express a view. I suspect that it's always intergovernment negotiation first and often last. I think the big issue there is to try and get interested domestic third parties who want to be involved. As far as I can see, there's quite a heavy desire to keep them out of the negotiating process, and there may well be one of the weaknesses of international law is that individuals or groups don't have any standing. It's only nations that do normally, and that is a big problem, I think, although nations are very unlikely to ever want to change that rule.
Any further questions?
One down here.
Oh, Tony, hang on.
You said that the...
Tony, could I just ask you to wait for the microphone, please? Thank you.
You said that the ANZUS issues with the New Zealand's anti-nuclear policy, we regard it as friends, but the US is still punishing us.
Well,
is that right?
No, it's not really. The dispute has been really put behind us in the sense that we're not members of ANZUS, but there has been a very substantial warming in the relationship, and the degrees of military cooperation have resumed to a pretty large extent. And I think most of the intelligence problems that were visited upon us have gone away as well. I think there's been a very significant warming of the relationship under the Obama administration. And I think that, however, it is not a relationship that is the same as it was before, and it will never be.
Any further questions?
Good.
Thank you, Sir Geoffrey, for that. What I was struck by was how similar the attitudes and actions of sovereign governments can be to parties in domestic disputes. But obviously the power imbalance problems are clearly and obviously amplified at international level. I think as Geoffrey said, the outcomes are dependent upon the political will of ministers to arrive at an accommodation, and I suppose it makes those of us who deal with say building disputes and sharemilking disputes and the like, they look relatively simple compared to what Sir Geoffrey has been dealing with internationally. So thank you, sir, for giving you the benefit of your experience, and I'd like the conference to show the acclaim in the usual manner.